Good afternoon, everyone. Welcome to the Dallas Volunteer Attorney Program's monthly CLE. Today we are talking about how to do no kids, no property divorce cases. For those of you that are not familiar with the Dallas Volunteer Attorney Program, or DVAP as we affectionately call ourselves, we are a joint project of legal aid in Northwest Texas, and our primary mission is to match low-income Dallas residents with private attorneys that will do their civil case from start to finish pro bono. We take a wide variety of cases, and one of the most common types of cases we see are folks needing help with divorces, and a good chunk of them don't have any kids involved and no property. So I've always been of the opinion that doing a no kids, no property divorce is probably one of the best ways to start doing pro bono work. And of course, if you're interested in family law, starting out with that easy no kids, no property divorce is the best way to introduce yourself into the family law world. So today we are blessed to have as our speaker Professor Shantae Brantley. She is a professor of law at SMU, and she is the founding director of the Van Sickle Family Law Clinic. And she's basically, through the clinic, supervises students representing clients in all types of family law matters. So she has done hundreds of these no kids, no divorce cases, and certainly an expert. She has also helped create the courthouse Van Sickle self-help clinic as well that helps folks, self-represented litigants, walk through their divorce cases. Prior to joining SMU, she worked for CPS, was in private practice. She got her Bachelor's of Science from Texas Women's, her Master's from the University of Texas at Arlington, and her JD from the University of Texas. She has a passion for volunteer work and has volunteered with DVAP for several years and has also been awarded the DVAP Lois Bacon Special Services Award. So as she goes through her presentation, if you have any questions, please put them in the Q&A at the bottom, and we will try to get to those at the end of the presentation. So without further ado, I will turn it over to Professor Bradley.
All right, thank you, Kristen. And thank you everyone that's here that has decided to take on a pro bono case, is curious about taking on a pro bono case. Hopefully, after this presentation, you'll see that it is a simple process and something to get you started in doing pro bono work. And hopefully you'll become a partner of DVAP long after you take this first case. So let's go ahead and get started. At the end, I will entertain questions, and Marcella will moderate the questions. So any questions that you have, you can put them in the chat. All right. So the purpose and goals of this presentation is basically to equip pro bono attorneys with the tools and the confidence to handle a no kids divorce in Texas, and specifically in Dallas County. And so by the end of this session, you should be able to understand the required forms, the timeline, the court process and procedures, and know where to turn for help and to get additional resources. So let's get started. What you'll learn today. So today you'll learn how to process the divorce, kind of the stages of the divorce. Then, of course, the forms, you'll learn the DVAP forms that you will use. And also you'll learn that in family law, a lot of what we do is form driven, meaning that there's templates, there's available resources. So it's something that you don't need to reinvent the wheel. You'll have everything that you need to process this no kids divorce. And then you'll learn a little bit about a step-by-step workflow on a no kids divorce. And then on finalizing the case, as well as getting the support that you need. So here I added, this is a list of the documents for the No Kids Divorce that DVAPs provide. So I'll just talk a little bit about the packet. So the packet that you get, it'll include some instructions. It'll have all of the templates on the pleadings that you need to file, all of the documents that you need to attach to those documents. You'll have things like the statement of inability to afford costs, which is basically your money and what the client's money and how they will pay for the filing fees or not have to pay for the filing fees. So all of the documents and everything that you need in the instructions will be outlined in the packet. And so I would encourage you to make sure that you use DVAP documents, because sometimes, you know, somebody may tell you, well, you can use this document. And so you don't want to use any documents that are outdated. So it looks like a long list, and you're probably like, oh, that's a lot. But you'll see that some of these documents you may need or you may not need. It just depends on what type of case it is, meaning that how you achieve service and whether or not it's a agreed and whether or not it ends up in a default. So let's talk a little bit about some of the basic law, some of the key concepts that you will hear and um, you'll definitely need to know that there's a residence requirement. So one of the parties must live in Texas or for at least 6 months in Dallas County for at least 90 days. And so I say Dallas County, but even if it was in a Tarrant County, the law still requires that one of the parties, just one of the parties, need to be have lived in Texas for 6 months and in the county in which you're filing the divorce prior to or preceding the filing of the divorce. In Texas, of course, we are no fault. Insupportability is allowed, and that's typically what is the grounds for divorce. In these cases, you don't have to prove any kind of fault grounds. There's a list of prove up questions that you either ask, or if you're filing an affidavit, that would be in the affidavit that basically say, hey, there is discord and there's no reasonable expectation for us to reconcile. And so if you show that, that's all you need to show. Of course, community property, the presumption is all property acquired during the marriage is presumed to be community property. And then separate property is property acquired before marriage or by gift or inheritance. And so that's a way that you can rebut the presumption of community property. If it was a gift between the spouses or something they acquired prior to the marriage. And then there's a mandatory waiting period. And in the waiting period is a 60-day waiting period after you file before you can finalize. And there's an exception, and that's the family law exception. If there's a finding of family law and that you may be able to avoid the waiting period. Name change. A lot of times in these cases, a party is wanting a name change. So the law says you can get a name change, but it has to be to the previous name used, such as a maiden name. Prove up required. So there is a record need to be made to finalize the divorce. And in these cases, you can do it by affidavit and what we call by submission. That's one of the simplest processes. And I'll talk about that a little bit more. Or you can do it via Zoom or in person. And in some cases, in some courts, and they may want in person is now Zoom. So you may not necessarily be able to go to the courthouse, but you can always ask. And I'll talk a little bit more about how important it is to look to the court's policies and procedures. And as a professor for my students, I like for them to have the experience of attending a court hearing. And sometimes, you know, the judges allow us to come in person, but always ask if that's something that you want to do. All right, let's go ahead and start unpacking the process itself. So the first step I have here is preparation and initial filings. So if you think about if you practice family law, are you a civil attorney or criminal attorney, do transactional work, but just think about even in your practice, when you prepare, there's some things that you would typically do in whatever case. So the skills that you already have as a lawyer, it can transfer to this pro bono case. Number one is you got to meet with the client. Meet with the client, and that meeting could be in person, it could be over Zoom, it could be a phone call. But you definitely want to kind of meet with the client to kind of talk about the basic facts of the case. And then there are some documents that you want the client to go ahead and to initiate and sign. And so these documents, you can send the documents via DocuSign or whatever process that you use for clients to sign documents. So one of the documents is the statement of inability to pay costs and the serviceman's affidavit. And all of that, those documents are included in the packet. But I want to talk a little bit about the affidavit of inability to pay costs or the inability to afford costs. When you send the document to the client, I would suggest that the caption, so there's a caption, which is the style of the case, and then you have to check it's in district court, put Dallas County, that needs to be filled out. I would say fill it out before you send to the client, before they fill out their portion. And you want to make sure that it's a complete document, because one of the things that we found and that could happen if it's incomplete, if you don't check that's in district court, there's blanks, the clerk is more than likely going to return it. So I would say on the front end, go ahead and you as the lawyer fill that out when you send it to the client, because they won't know to fill that caption or the style of the case. And then the serviceman affidavit, that's just basically an affidavit that talks about whether or not the party is in the military or not. It's a federal law, so that's something that the client can initiate. And then in the preparation phase, you want to start drafting. And I have the word draft, but you'll have a template that's already got you started. And so you kind of fill in what needs to be filled in based on your interview with the client. But let me just go back. You'll get a packet of where the client has been interviewed, maybe by a volunteer at an intake, right? So sometimes they may not capture all of the information. And so it's always good to go back and do your own interview, because there may not have, information. They may say, just say, for instance, I don't have any kids. We don't have any kids. And then you get into the case and you're like, okay, the couple don't have any kids, but the wife had a child. And so that's a whole nother issue. But even in a uncontested in a basic divorce, that still is a process that is easy or simple to fix. And so always go back and kind of do your own interview and intake with the client as well. And then after you do your drafting and you got this nice document and it's ready to go, e-file it. E-file your original petition. And then there are some attachments, like in Dallas County. We have a Dallas County standing order. It's just an order. It applies to both parties. Nobody initiated. It's just an order where the court tells the party how they're supposed to act and interact with one another during the pending of the litigation. And then there may be some documents if needed, the affidavit for citation. And then basically that's if you're you don't know where the party is, and they saying, well, I don't know where they are, and you're attempting to try to get service by posting. You've done all of the diligent efforts to locate and the client. You got to engage with the client, because they may say, well, I don't know. But they say, well, I have a phone number. Okay, we need that phone number. We need to call. We need to figure out, because if you can avoid trying to do the posting, and you can really either get them to fill out an affidavit, the waiver of service, or get them personally served, that's always a better option. So you may not need these posting forms, but it all depends. Then one of the things I want to kind of talk about is, in these cases, we are only supposed to use their last 3 digits of their social security number and driver's license number. And then after you file, it's gonna be randomly assigned. Randomly assigned. Dallas County has 7 family courts. And so based on whatever court your case is filed in, I would say immediately go ahead and look on their website. And on their website, they should have, well, most of the judges have policies and procedures. And if for some reason there's no policies and procedures posted, you can always ask, you can always pick up the phone, call the clerk, call the court coordinator, or you can reach out to DVAP as well. But it's very important that you not only read, but follow the court's policies and procedure, because that's the first thing when a student asks me, I say, well, have you read the court's policy and procedure? Because Professor Brandley is only limited in what she can actually do. So make sure you follow and you read the policies and procedures. All right, let's move on to the second step. So you got your petition, it's all filed, it's accepted, and even e-filing. DVAP have some e-filing instructions that are specific to these family law cases. So you got it e-filed, you got it accepted, you're all excited. Of course, you're gonna give your client, the client, a copy of the e-filing and the petition, so they have it as a part of their record. So some of the same thing that you would do in your practice as either civil, in terms of how you engage in your attorney-client relationship, you would do it the same here in the DVAP case. So let's talk a little bit about service, giving legal notice. So the best option for these cases, of course, is a waiver of service. That's where the respondent is waiving service. They're saying that, hey, I got a copy of the petition. I'm waiving service, so I don't have to be personally served. And then just make sure that that this occurs after you file. So it needs to be the next at least, the next day, but definitely after the petition is filed. And then the waiver of service must be in front of a notary. And so I want to emphasize, make sure you use DVAP's waiver of service. So that's the first option for legal notice. And you probably recognize some of these. These are methods of service, so that we can use in any practice area, because it's a part of the Texas Rules of Civil Procedure. So then the next option, of course, is personal service. And then this is when you know the respondent's address, whether it's work, home, or how to get them served. And there is no agreement. But let me just, when I say no agreement, that's not necessarily mean that this is going to be a contested matter. Because always keep in mind that one of the things that's good about these cases, number one, there is no kids. There's typically probably limited property, things like, my cell phone, maybe a car, or the clothes I have, or, the furniture that I have in my apartment or in my home. So, but maybe they just not willing to sign a waiver of service, but they're okay with signing the final decree. So that's, just keep in mind that personal service is still a good option in these no kids divorce. And one of the things that, if you already know that you're not going to get a waiver, you have the address, you can go ahead and request the citation to be issued at the time of the filing. And all of that could be done through e-filing. Another third option is under Rule 106, alternative service. That's if, service fails, things like, the respondent, he lives there or she lives there, but they're never at home, or they're avoiding service. Then you can request a alternative service under Rule 106. You can reach out to Catherine or Kristen for the motion and order. And then the last one as an option is service by posting. And this is if there's, no kids, and typically there's, no probably, but definitely no kids. And that's when you're the respondent's residence is unknown. I mean, they're saying they don't know where the respondent is, it's unknown. Plus, diligent efforts have been made to locate. So you will see like diligent efforts. Did you look in the phone book to try to reach you? Did you contact the relatives? The last information that you had, did you send an information to a former employee? So those are the kinds of things that needs to be done before requesting that requesting that the court grant you permission to do it by posting. That's basically posted at the courthouse, and eventually it will end in a default. So just make certain that at the end of the day, we're really saying that the respondent's whereabouts are unknown. So that's legal notice. Then after we get into legal notice, we're here. Okay, so we got the respondent's response, and just like in any other case, the respondent may get served, and then if they get personally served, they have, just like in most cases, respondent has the 20 days after. I mean, they have 20 days plus the Monday next. So you count your 20 days and then the Monday next. So if your 20 days fall on a Monday, the Monday next is the following Monday. So just remember that piece, that is the following Monday. And if no answer, you can proceed with a default. And if there's an answer, then they can file an answer, or they can appear in court, or just send in a note. Typically they'll accept it as an answer. Then you have to get an agreement, meaning that you have to ask them to sign the final decree, and keep them involved. Let them know about the different hearings. Any filings that you file, you have to send them the information. So it would be the same just in any other civil case once a respondent file an answer. But just keep in mind, even here, you're still in the 60-day waiting period. And so you can't just go ahead and proceed. You still have to wait the 60 days if you hadn't received an exception to the waiting period. All right, step number 4. Now, we're down to, we got the petition filed, we got good service. Now we can start drafting the final decree. And you want to use the DVAP divorce decrees, their templates, the forms. And the decree that you choose will depend on the type of legal notice or the service. So say, for instance, there is a decree by affidavit, and that's basically where you have an agreement, they've signed a waiver, or they didn't sign a waiver and they filed an answer, but they decided to sign the final decree. And then you have what is going to be labeled decree in person. This is when there is either you got a default or you have a waiver. And then a decree in person and posting. Remember, we talked about posting. So if you got legal notice by posting, then there is an actual decree that you're going to use for the posting. So all of the decrees, for the most part, has all of the language, has everything that you need in it. You just need to fill it out and complete it based on the type of case that you have. And a lot of times you'll kind of know what type of case that you have based on your legal notice, based on whether they waived. Usually if they file a waiver, that means, yeah, you can move forward, or you have an agreement. But if you have a default, most courts, as you'll see, they may want you to make a record, but there are some exceptions to that. All right, next, after we've drafted the final decree and we're ready. I mean, we're finalized, we're ready to prove it up. But one of the things you want to think about, okay, am I really ready? And this is how I can determine whether or not I'm ready. So if at least 60 days have passed since the filing, right? So remember the 60-day waiting period, you got to make sure that the 60 days have passed. And usually the day you file, your 60 days starts day 60, um, the next day after you filed. And so we generally say we're ready for prove up on day 61. And one of these other the following, they apply based on the type of case. It is you have the respondent if he was served but did not file an answer. And then this is key. The return of service has been on file for at least 10 days. And so thinking about, okay, I need to make sure, okay, didn't file an answer, but I needed the return to be on file before at least 10 days before I'm ready to prove it up. And then if the respondent signed a waiver or service, respondent filed an answer or made an appearance. And if they filed an answer and made an appearance, you definitely need an agreed decree of divorce has been signed. Then you know that I'm ready to move forward. And at this point, the case can be finalized through the prove up process. So just think about, okay, have I met all of the requirements? Have the 60 days has passed? Do I have good service? If I have good service, do I have all my documents drafted and then you can, you follow the court's policies and procedures based on what type of case you have, based on whether or not you want to just do it by submission, set it for a hearing, but always look to the court's policies and procedures. And most of the judges have policies and procedures, and then you can just look and see where it says prove ups, and they'll tell you, okay, I do. Some of them, they'll say I do prove ups on Wednesdays and Fridays at 10 a.m. You need to reach out to the court coordinator to set your case. So always refer back to the policies and procedures. All right, so let me just talk just generally about the prove up procedures. So, you heard me talking about prove up by submission and then prove up by Zoom. And when I say prove up by Zoom, that's almost sort of like a making a record. So it's a court hearing. You just in Zoom. And I'm sure that most of everybody is still using Zoom as an option for a court proceeding. So prove up by submission. All right, so we got the respondent had signed the waiver or a final decree, because approval by submission, you need to have an agreement. And so typically you're saying to the court, we have an agreement, so I'm going to e-file the final decree. I'm going to e-file the proof of affidavit. And the proof of affidavit is basically the questions, if you were doing it in person, is basically the legal questions that we would ask, but they would actually be written in an affidavit. And then you'll also want to e-file the Austin form. So I typically e-file the Austin form. Anything that I need to finalize the case, I typically go ahead and file it. But I want to make a note that Austin form, a lot of times they'll send it back. You'll see this return. Don't panic, because the Austin form actually goes to Austin, to the Texas Vital Statistics. It doesn't actually stay in the e-file or in the record. So they'll send you a note back. Hey, we got it. We're going to hold it. And at the end, we'll go ahead and send it off to Austin, to Vital Statistics. And then when you're e-filing, like I said, there's some e-filing instructions. You just want to add in the comments section, dear clerk, can you submit this decree to the judge's queue for signing? or for prove up by submission. So if you do that, you have all of the documents e-filed and accepted, the clerk will go ahead and put it in the judge's queue, and 9 times out of 10, once the court reviews it, they'll go ahead and sign it. And for the most part, sometimes you may get a copy of the sign, but sometimes you may not. But don't worry. There is ways in which you can get a copy of the final decree and the documents that you need. But one of the things that I want to say that, like, we usually get a certified copy, but if you do it by submission, you won't, if you don't go in that day to get a certified copy or somehow, request a certified copy, you have to do it at a later time. It was, we was in person. We, submit the order, submit everything we needed, go to the clerk's office, get our certified copies. But it's a little bit different now. But you definitely can get a certified copy, and you want to get a certified copy of the final decree for the client. But just keep in mind, if some issues that you can't get something or whatever, you have support, whether it's DVAP can share with you how you can get the documents. Let's move on to the Zoom hearing. That's cases that need a record. And so in that case, I would say go to the Pacific Court and figure out, what the court's procedures are. Some courts require you to schedule it, and but always confirm the court process ahead of time. All right, so we're down to the final summary, and here this slide just talks about kind of pulling it all together, the stages versus the timeline. So the stages is basically what happens. And so when you think about, okay, what happens in a no kids divorce? We already talked about, you got intake, you got filing, service, or the waiver. The waiting period, this is where you monitor things. The waiting period where you monitor things, you're drafting the final decree, and you're getting everything together during that waiting period so you can prove up and finalize the case. And then thinking about timeline, okay, what happens during the timeline? You got day one, you got the petition, you can file it. Then think about the 60-day waiting period. Services usually. And you can make these timelines. These are just suggestions. You can make your own timeline. Day 1 to 2, that's when you want to kind of achieve service. And then the answer period. And then, of course, the prove up when it's allowed. And like I said, usually day 61. And then remember the 10+ days. This is when the return of service must be on file before you prove it up. So having an understanding of both the stages and the timeline, that's going to help you manage the expectations, meaning your expectations and the client's expectations, and then help to meet the deadlines and avoid any kind of delays. All right, we're down to your resources and support. So this slide is talk about, there's a free e-filing on Texas courts, and most people probably are familiar with the free e-filing. The phone number to the district clerk's office, and then the DVAP waiver and the forms. I keep talking about that waiver. I mean, when you got to have a waiver of service, like I mentioned, that's the best option. And that's usually in these cases, typically you can get a waiver of service. And then, of course, you have your DVAP mentors. You have support from the SMU Family Law Clinic. Here is my email at cprox@smu.edu that you can reach out if you have any questions. And right now, I'm going to pause and just, thank you for listening to my presentation, for showing up, for agreeing to take a pro bono case. Trust me, if this is your first, you're going to be really excited and feel really empowered by taking a DVAP case, and you're going to be assisting someone who needs some assistance. So I'll stop here and entertain questions. do I have any questions? And I'll turn it over to Marcella if you want to.
Thank you, Shante, for a
Yeah.
wonderful presentation. Let me go ahead and pull up the Q&A. As we
Mhm.
mentioned at the beginning of the presentation, feel free to enter your questions in the Q&A box at the bottom of your screen. Let me see. For those asking about a copy of the slide deck, yes, we will provide a PDF version of today's presentation, and that will be emailed to you within the day of via Zoom. So you'll receive that via email. Question, how to know if a decree by affidavit or in person when you use waivers? Do you understand that, or should we ask for further? I think we need further clarification if you don't
Yeah, we might
mind.
need clarification.
Let's see, what else?
So are they asking, how do you know the difference in which decree you use and whether you,
While they type in further clarification, maybe you can do a further explanation to what you just said.
I think I can probably clarify that. So
Mhm.
the DVAP forms have two sample waivers. One is labeled by affidavit. So that is used when you are submitting the decree for submission, like Shante was talking about earlier. And the other form is labeled in person. And that is used when you are going to have to do a prove up either in person at the courthouse or over Zoom. Um, Feel free to clarify that, Professor, if you so feel like.
I think that if you look at it in terms of the affidavit, the affidavit is only used if you're doing it by submission. And by submission, that means that you have an agreement. That person has either signed a waiver of service and in signed a waiver of service, or that person has either they could file an answer, but they will sign the final decree. So that's still considered an agreement. And so that's when you can do it by submission. Nobody really goes to court. You just submit all the documents to the court. And the waivers, I think that's sort of kind of how I would look at it. You know, if I have a waiver, then I'm more than likely will have an agreement. And so I'll use all of the documents that DVAP provides that's in line with an agreement. And then thinking about, okay, how do I want to prove it up? How do I want to finalize it? Do I want to do it by submission? Or if I want to do it in person, because your final decree will tell you how you appear. So if you do it by submission, the final decree will say something about parties appeared by submission. It won't even say that anybody appeared in person. Or if you want to do it in person or over Zoom, then your appearance language would change. So that's kind of the difference in the waiver, I mean, in the final decree. For the most part, most of the language in the agreements, it's going to be the same. But when you get to how the parties appeared, or then that may change, or how they were actually served. Were they served by waiver? Were they served um, by personal service and they defaulted? So when you look at the final decree, then that's really the only thing that's going to be changing in the decrees and the difference. So hopefully that helps. But if you just think about how I'm going to get legal notice to the respondent, then I will determine what type of case it's going to be, whether it's going to be waived agreement or it's going to be a default. Then I will determine, okay, in my final decree, I will choose it based on the type of notice that was achieved in the case. Hopefully that helps.
Okay, thank you. Here's a question. Is the service by sheriff or constable free if a statement of inability to afford cost is on file?
Yes, it's free. And let me say the statement of inability to pay costs is under Texas Rules of Civil Procedure 145. And typically, if they are actually receiving certain kind of benefits or really is perceived unable to pay the costs, and it can't be challenged. So the answer to your question is yes. And then I would highly recommend that you all take a look at Texas Rules of Civil Procedure 145 to have an understanding of the why and the behind the form, beyond that it would pay for the cost.
Okay. What if a party has criminal charges or is incarcerated? How does that affect the service of process?
Oh, well, that's the perfect here in the clinic. If they're incarcerated, I know where they are. If I can find them, I will get them personally served. I wouldn't ask them to sign a waiver. I wouldn't ask them to do any of that. I would just locate where they are and then get them personally served. And then if they're incarcerated, some I've had cases where some don't file a response and you get a default. And then in some cases, they might file a response. We have one in the clinic, they file a response, but they eventually sign the final decree. So that's a case where you know where they are, and you can use personal service. You can attempt the waiver and send them the letter and see if they're signed the waiver. But I think I'd probably recommend just get them personally served if they're incarcerated.
Next question. What if the client says the respondent has said that he will cooperate, no kids, but respondent decides he wants to make an unexpected claim for property division or decides to appear pro se and contest the divorce? What
All
then?
right. That's a good question. And so let me just kind of unpack that a little bit. So even in these cases where they are typically limited property, I'm not really for sure what they may contest, because at the end of the day, if they don't really have anything, there's really not a whole lot to contest. But say, for instance, if they do contest and file an answer, then you may have to you may have to add an extra step into the process. It depends on what court you're in, whether or not you can go through mediation. You can attempt to still try to negotiate and resolve it that way. But if they attempt to, I'm assuming that when you said they're contesting it, they are filing a response. Is that was the question again?
So, the respondent decides he wants to make an unexpected claim for property division or decides to appear pro se and contest the divorce. So yes, they do respond pro se.
Okay, all right. So they can respond and they can contest, but in these cases, it's a no kids. So you don't have any of the SAPs or the suit affecting the parent-child relationship to talk about custody and child support, and they want to contest the property. Well, you have to think about, okay, what property actually do they have? And so you may have to, again, that may delay it some. And you have to, if say, for instance, if it was some property, if they had like a car, then a car, okay, or no, let's see, yeah, I guess a car could be a car, or whatever the property is that that they want to contest. Then you can talk with the client and kind of see, okay, is this something that you are okay with allowing them to have? So you kind of still go through the negotiation process. And then if it's just where they won't sign the final decree because they still got this issue, then you have to put it on either the pre-trial docket so that the court can set it for a trial. But just keep in mind that if they don't have a lot, and I'll give you an example. There's a case that we had. They really didn't have anything. He just didn't want to get a divorce and wouldn't sign the final decree. So we had to set it on a pretrial, give him notice, set it for trial, show up, and at the trial, we basically just asked our proof up questions because you can't prevent a person from getting a divorce. You can only delay the process. So answer to that question, it may have some delay, but you're still going to be able to get that, get your client divorced.
Okay, thank you. And then we had a few questions about today's MCLE course code, so I will read that aloud now. That number to get your credit is 174-284-717. Again, that is 174-284-717. And I will be emailing that out as well. So please look for that in your email within the next day or so. Let's see, and additional questions. Here's a tech question if you may have an answer to this. Do you have any suggestions for a software that can perform the function of converting the documents to readable PDFs, aside from Adobe, I'm assuming?
Readable PDFs. No, I believe that what we have here is the only, is Adobe. I
It's
don't
Adobe.
know any other.
Okay, thank you. And yes, if you would like a link to today's recording, please email me and I will put my email in the Q&A. So you can email me directly. And then one last question about the criteria for financial requirements. I'm assuming that is in order to file the inability to afford court costs. I'm sorry, for the individual who asked that question, I might need further clarification. And you can also email myself or Kristen, especially regarding a DVAP case.
If I can, let me just for that case, for that question and try to, in terms of, so DVAP has already screened them in terms of their income. And so they've already decided that they meet the qualifications. And then in terms of to receive services through DVAP, and they're at that income threshold. And so when you file the affidavit inability to afford costs, you'll get a legal certificate, meaning that that's a document that you file. You're going to check a box in the form, and then you're going to attach the legal aid certificate, because it's going to say that this client is being represented by a legal aid provider. And then that in itself will say that they're eligible to submit the affidavit inability to pay costs.
Thank you. All right. And yes, I will email the CLE course code and today's slides. And if you'd like the link to the recording, I've included my email so you can reach out to me directly. But thank you all for joining and today's presentation. Thank you to Professor Bradley for your time. We really appreciate you. And if you do have any questions following today's presentation, please feel free to reach out to myself or Professor Brantley, which her contact information will be included in the slides that I will be emailing you. We wish everyone a great rest of your afternoon. And thank you again for joining a DVAP presentation. Thank you, everyone.
Thank you.